May I have your attention? Please take your seats. This is our final speaker. We save the best for last. Our next speaker is a lifelong Memphian and a graduate of Central High School. He received his Bachelor of Arts degree in Political Science from the University of Memphis in 1994 and his Juris Doctorate degree from the University of Memphis School of Law in 1997. We know that he's been a practicing attorney with FedEx. It's just amazing how people can say FedEx. And he is now the United States Attorney for the Western District of Tennessee. Our speaker is Mr. Edward Stanton.
All right. Can you guys hear me okay? Okay. Well thanks, Doris, for the kind introduction. It's certainly a privilege to be here. In fact, a couple of you have actually asked me, what are you doing here? How did you get on this kind of a program? I won't point you out. I will make one observation, and certainly to our esteemed judiciary, members of the court, it's a pleasure to be before you. But I want to make one observation. I've noticed how, Doris, you've been able to stay so cheery and lively and bubbly this morning. But as I was looking over, I was trying to find a podium, and I happened to find something. Oh, you put it up. Okay. Okay. It's in the box. So now I understand that little black cup that she has. We'll call it Good Friday Communion, I guess. I don't know, but listen, I know that I stand between you and lunch, so I'll be brief. I do want to make just a few observations as it relates to ethics and certainly the Department of Justice and specifically our office, the United States Attorney's Office for the Western District of Tennessee. And so 4 points I want to make with regard to some of the things that we're doing. Of course, it was just 8 months after the Gideon decision on November 1st, 1963, that then Attorney General of the United States, Robert F. Kennedy, spoke in Boston before the New England Conference on the Defense of Indigent Persons. And he spoke about how momentous the Gideon decision was, and he said this, and I thought it was worth noting. The Department of Justice recognizes that in its role as the criminal prosecutor for the federal government, it has a special responsibility for the development of procedures that will result in an adequate defense of all indigent persons accused of crime. And even now, as the present Attorney General, my boss, Attorney General Eric Holder, has stated, our criminal justice system and our faith in it depends on effective representation on both sides. The Justice Department is providing a number of tools and resources to help establish effective indigent defense systems across the nation. And that's somewhat what I want to talk about briefly. First, the ethical obligations of the U.S. Attorney offices, including ours here in West Tennessee. The ideals articulated in Gideon versus Wainwright are fundamental to the values that I have, along with my 92 other colleagues, U.S. attorneys across the country, who prosecute federal criminal cases on the behalf of the United States. While all of us want to see guilty defendants held accountable for their crimes, a fair trial depends on a vigorous and thorough defense. Defendants have a right to eliminate potentially biased jurors through questioning, to effectively cross-examine prosecution witnesses, to find and present witnesses of their own should they choose to do so, and to present thoughtful opening statements and closing arguments. Someone untrained in the law finds himself on an uneven playing field when forced to perform all of these tasks himself or herself against an experienced litigator and prosecutor. And it is the experienced prosecutor who, in turn, who has an obligation to ensure that access to effective lawyers is being provided at the critical stages of criminal proceedings. Our system of justice, it depends on an adversary system where the lawyers stand on equal footing. We can all feel more confident that justice is served when we know that defendants have access to effective lawyers to represent them. Prosecutors should not just be thinking, I believe, of the most punitive sentence available. We have an ethical obligation to do justice and to administer the law in a way that is equal to all. And because we are not the Department of Prosecution, I'll say that again, we're not the Department of Prosecution, we are the Department of Justice, and etched on the walls of the 5th floor of the Robert F. Kennedy Department of Justice building in Washington. I was there just a few weeks ago in Washington with Attorney General Holder in meetings. But there's some important, on the Attorney General's rotunda, these important words are etched. The United States wins its point whenever justice is done for its citizens in the courts. And I'm proud today to be working for a Department of Justice that has made real progress to ensure justice for all. Most of you are aware of the Department's new charging policies announced by the Attorney General, as well as the force that he's putting behind the initiative that's called Smart on Crime. And I'm going to speak in just a few minutes about the Smart on Crime initiative and the charging policies. In just a moment, I'll speak in that regard. But there are other examples of what the Department is doing to promote equal justice and access and the right to counsel. The Office of Justice Programs made nearly $7 million in grants last year to improve legal services for the poor. That sum included a $1 million grant to Gideon's Promise, which is a group that partners with public defenders' offices to build a community of attorneys committed to indigent defense reforms. The grant will provide 25 new attorneys and establish training and leadership development programs for public defenders. And nearly $2 million in grants were given for a program titled Answering Gideon's Call, which works to improve the effectiveness of right to counsel services. Another part of the Office of Justice Programs, the National Institute of Justice, recently funded 3 research projects that are currently underway. These include an evaluation of holistic defense methods, an evaluation of the factors that affect juveniles' waiver of counsel, and an examination of the challenges of representing indigent defendants with mental health disorders. These are all welcome developments, and because they fulfill the ethical duties that we prosecutors have to the justice system to ensure that the rights of the indigent have real meaning and teeth. Second point, ethics in action, as we talk about the Smart on Crime initiative. As many of you know, the Department has recently announced some significant policy changes that touch on many of the themes that we've discussed on today. And I see these changes as fully consistent with, in fact, if not a natural outgrowth of the prosecutor's ethical obligations to ensure equal justice. In August, you may recall last year, it was in August at the American Bar Association annual meeting in San Francisco, Attorney General Holder announced the Justice Department's Smart on Crime initiative. And before I give you some of the details of this initiative, let me provide a few statistical background facts. While the entire U.S. population has increased by about a third since 1980, the federal prison population has grown by almost 800%. And it's still growing, despite the fact that the federal prisons are operating at nearly a 40% above capacity rate. In fact, even though this country comprises of just 5% of the world's population, we incarcerate almost 25% of the world's prisoners. More than 219,000 federal inmates are currently behind bars. Almost half of them are serving time for drug-related crimes. Roughly 40% of former federal prisoners and more than 60% of former state prisoners are rearrested or have their supervision revoked within 3 years after their release, at great cost, obviously, to the American taxpayers, and often for technical or minor violations of their terms of their release. There's also the reality that once they're in the criminal justice system, people of color often face harsher punishments than their peers. One deeply troubling report released in February indicates that in recent years, black male offenders have received sentences nearly 20% longer than those imposed on white males convicted of similar crimes. And sadly, a study of inmates in North Carolina just a few years ago showed that black men typically live longer in prison than out of prison. Why? Because they have access to health care and they're protected against alcohol and drug-related deaths and chronic diseases, all while on the inside of a facility. I will tell you, these numbers are certainly startling and, quite frankly, unacceptable. The Smart on Crime initiative is a bold response to these trends. It provides a measured and recalibrated approach to modernizing the criminal justice system. It also offers a sensible alternative to the one-size-fits-all approach to criminal prosecutions that has proven to be somewhat flawed and ineffective over the past 3 decades. So here are the 5 key objectives of the Smart on Crime initiative. First, focusing on the most serious criminal cases that implicate substantial federal interests. 2, reforming sentencing laws and policies. Thirdly, pursuing alternatives to incarceration for nonviolent offenders. 4th, improving reentry efforts. And 5th, protecting the most vulnerable members of our communities. Now, I'm pleased that in the Western District of Tennessee, we've had a head start on implementing strategies that further these objectives. In fact, for example, our office has worked with the U.S. District Court to launch a federal reentry and drug court. And I'm happy to say, even as we speak, we're working with individuals from the court, Chief Judge Breen, probation services, pretrial services, and even recently the Federal Public Defender's Office, all working in this same arena to address some of these issues that I've just mentioned. We will continue to seek ways to reduce barriers to reentry for former inmates and eliminate the revolving door of recidivism, which is both expensive to the taxpayer and disruptive to families and our communities. The department as a whole has put tremendous resources into reentry and emphasizing the need to make sure that prisoners rejoining society have the necessary skills to be able to put their lives together once they're released, to obtain jobs and support their families. In fact, in every U.S. Attorney's office across the country, including ours, we've designated a prevention and reentry coordinator. And I'm pleased to announce that AUSA David Biggers has taken the helm. I appointed him to this capacity. These coordinators are charged with leading and tracking U.S. Attorney offices in efforts to prevent violent crime and to help former prisoners reestablish stable lives and break the cycle of incarceration. These efforts by U.S. Attorney offices may include, for example, reaching out to potential employers to explain the benefits and opportunities of hiring former offenders. And we in the Western District of Tennessee, we have also emphasized the use of diversion as an alternative to incarceration when warranted for non-violent offenders. Imprisonment is simply not the answer in every criminal case. Across the nation, states have been shifting resources away from prison construction in favor of treatment and supervision. And it's time, I believe, to apply these lessons learned from the state at the federal level. And to enforce these laws more fairly and in a more cost-effective way, our prosecutors are now taking a hard look at each individual case and each individual defendant to determine what's the best course of action, what that may be. And I often echo and say something I've heard the Attorney General say, and that is, I'm not worried about conviction rates or how much money prosecutors recover in fines. Certainly that has its place. But I remind them with great power comes great responsibility. And simply the only thing that I want the prosecutors in the office to do is do the right things and simply to do justice. Supreme Court Justice George Sutherland, he underscored this theme in writing for the unanimous court in 1935 in Berger versus United States when he said that the United States attorney may strike hard blows, but he is not at liberty to strike foul ones. And in this regard, let me emphasize. You guys hear me? Okay. The executive branch has fundamentally re-examined the notion of mandatory minimum sentences for drug-related crimes. Some statutes that mandate inflexible sentences, regardless of the individual conduct at issue in a particular case, reduce the discretion available to prosecutors, judges, and juries. So under this Smart on Crime initiative, we've modified charging policy so that certain low-level, I repeat that, low-level nonviolent drug offenders who have no ties to large-scale organizations, gangs, or cartels will no longer be charged with offenses that impose draconian mandatory minimum sentences. We will be able to reserve the most severe penalties for serious, high-level, and violent drug traffickers. Along these lines, we continue to work with our law enforcement partners to ensure that our scarce resources are devoted to going after the worst of the worst, and not just in drug cases, but in all cases, in protecting the most vulnerable among us. For example, it was about a little over 3 years ago, I created a dedicated civil rights unit right on the steps of the Lorraine Motel, and we launched this unit in our office back in 2011. Their diligent work, this unit's work, has resulted in groundbreaking and successful prosecutions of sex traffickers, corrupt public officials, as well as hate crimes. We also have a nationally recognized Project Safe Childhood program, which fights the very real threat of child sexual exploitation. Now, something I want to be clear about as I talk about Smart on Crime, and while we have a number of defense counsel here, that this Smart on Crime policy, this is not a hug a thug policy where everybody comes in with a violin and a sad song, says, hey, my client deserves some special treatment because of the Smart on Crime policy. I want to be clear, our office and our law enforcement partners, we won't let up. Whether it's in the inner cities or the rural areas of West Tennessee, we will continue our relentless pursuit of those who commit acts of terror, criminals threatening and wreaking havoc in our neighborhoods through senseless acts of violence, and those who commit fraud and financial crimes, and those who prey upon vulnerable victims. But while we would never stop being tough on crime, we can also be smarter on crime, prioritizing prosecutions and surging resources to the most critical areas and cases will allow us to save money from the system of mass incarceration that has done very little to make us safer. Thirdly, as we talk about ethics in action, I want to share with you some of the things that we're doing in the Department of Justice, the access to the Justice Initiative. It was out of an ethical obligation to ensure justice that President Obama and Attorney General Holder launched that Access to Justice Initiative back in 2010. Now, this initiative established a new permanent office focused on enhancing access to criminal and civil legal services for those who cannot afford them. The mission of the Access to Justice Initiative is to help the justice system efficiently deliver outcomes that are fair and accessible to all, irrespectively of wealth and status. The initiative staff works within the Department of Justice across federal agencies and with state, local, and tribal justice system stakeholders to increase access to counsel and legal assistance and to improve the justice delivery systems that serve people who are unable to afford lawyers. Access to justice is guided by three principles. First, promoting accessibility, that is, eliminating barriers that prevent people from understanding and exercising their rights. Second, ensuring fairness, delivering fair and just outcomes for all parties, including those facing financial and other disadvantages. And thirdly, increasing efficiency, delivering fair and just outcomes effectively without waste or duplication. And the fourth and final point I want to make is ethics in action, next steps in building partnerships, what we're doing as far as the next steps. Now, we all know that the budget cuts that we've seen in recent years threaten to underfund indigent defense systems. And as I've mentioned to a few of you all on this morning, I'm happy to announce that we actually have a budget now, and we're in the process of bringing on at least 5, maybe 6 AUSAs between Memphis and Jackson, and we have been understaffed for at least the last 2.5 or 3 years with hiring freezes, sequestration, and budget cuts. But the current problem is not denial, in my estimation, of representation, as in Gideon, but of underrepresentation, which occurs when indigent defense systems are hampered by insufficient resources, overwhelming caseloads, and inadequate oversight. But the truth is, an inadequate indigent defense system presents added costs to taxpayers. When the justice system fails to get it right the first time, we all pay, often for years, for new filings, retrials, and appeals, while the real perpetrator of the crime goes free. And not only is criminal defense a fundamental right, but it makes economic sense. And across the country now, many of the department's U.S. attorneys are also engaging with the defense bar to address areas of mutual concern. U.S. attorney offices have partnered with federal defender offices to hold joint training sessions and joint public forums on the importance of jury service and jury diversity. The department has also been working with federal public defenders and counsel appointed under the CJA to develop and implement best practices for dealing with electronically stored information, or ESI, during the discovery process. As I conclude, I want to just share with you, I want to leave a quotation with you about the responsibilities that we have as lawyers. And we all know the story of Harper Lee's To Kill a Mockingbird and Atticus Finch, who was appointed to defend the wrongly accused Tom Robinson. But he said this in the following. He said the following in his closing argument that I want to share with you. He said that there is one way in this country in which all men are created equal. There's one human institution that makes a pauper the equal of a Rockefeller, the stupid man the equal of an Einstein, and the ignorant man the equal of any college president. That institution is the court, and it can be the Supreme Court of the United States or the humblest justice of the peace court in the land, or this honorable court which you serve. Our courts have their faults, as does any human institution, but in this country, our courts are the great levelers, and in our courts, all men are created equal. And so whether it's a criminal or civil case, the underlying unifying principle in our courts is that everyone is created equal before the law. And the Gideon decision was essentially making that point a reality. And again, I quote from Robert Kennedy's remarks on Gideon when he said that if an obscure Florida convict named Clarence Earl Gideon had not sat down with a pencil and paper to write a letter to the Supreme Court, and if the court had not taken the trouble to look for merit in that one crude petition among all the bundles of mail it must receive every day, the vast machinery of American law would not have gone on functioning undisturbed. But Gideon did write that letter. The court did look into his case, and he was retried with the help of competent defense counsel, found not guilty and released from prison after 2 years of punishment for a crime that he did not commit. And the whole course of legal history has been changed. I often say that in our office that certainly no one is above the law, but at the same time, I truly believe that no one should ever be below the law. Thank you all so much for inviting me today, and God bless you.
Mr. Stanton, you got time for a few questions?
Sure.
We're going to open it up for a few questions for Mr. Stanton. If anyone has any questions, we're just going to take a few for a few minutes.
Seeing there are no questions out now.
Mr. Ward.
Well, let me say this. What I mentioned in Smart on Crime, what it deals with is the way that we charge certain individuals and when mandatory minimums kick in. And again, I'm looking for the worst of the worst and not necessarily low-level, nonviolent offenders. And so I know that obviously we have the courts here, but I think a lot of what you're asking is more so an issue that's going to have to be addressed by Congress. But Smart on Crime is a more recalibrated approach to how we are charging. And it's simple. So that is kind of the charge from Attorney General Holder with the Smart on Crime initiative, that we're looking at each case on a case-by-case basis and determining when mandatory minimums and when the stiffer penalties, when we should seek those cases, and when we shouldn't, when an alternative, whether it's state court or whether we should not look at other alternatives such as pretrial diversion and probation and things of that nature.
Okay, so it gives your office the discretion to decide what you're going to do or what you're going to recommend to the courts?
Yes. More so in the charging of cases. Thank you, Mr. Warden.
Your office has always had diversion vacancies. How is that going to change?
Well, I will say this, and I think the courts, I don't know all the statistics, but when I looked at them, that over the last, it'll be 4 years that I've been the U.S. Attorney in August, and every U.S. Attorney has discretion and has a certain policy of his or her own, but it's an available tool that I believe should be a part of the tools in the toolbox. And again, I'll go back to say that, in fact, I see a few of you all that have had clients in suggested and proposed diversion. And I think many of you all have told me this has never happened in the U.S. Attorney's Office. I know it's been a tool that has not been used a lot, and I think it should be saved in rare circumstances. But I think, again, it's more so collectively than more so in the last 7 or 8 years collectively. So we look at everything on a case-by-case basis. I don't think there's ever been a defense attorney that said, hey, I think this person is eligible. Obviously, we have the guidelines of the Department of Justice, the U.S. Attorney Manual, procedures and protocol, and so there are certain cases, obviously, that doesn't fit in that box, but I think, again, it should be yet another, and that's being smart on crime, another tool in the toolbox when warranted to utilize. I think Mr. Warden had a question.
General, thank you. Quick question in terms of, similar to Ms. Harris's question pertaining to sentencing guidelines, particularly mandatory minimum. You use the word that you're often finding low-level offenders. And I'm not boxing you, it's not a particular scenario, I'm just asking in general. You got somebody who has never had an offense such as what you're often maybe find as a high-level drug conspiracy. But that person is charged in a conspiracy. Is there discretion that you're allowed in terms of saying, look, this case doesn't fit the criteria of low-level case or low-level offense. That person's circumstances are a little unique in terms of how they're brought in and their mitigating factors. So how is your discretion there in terms of from the charging side or even after the charging side, after the case is charged, to allow you some flexibility using those objectives you're talking about?
Yeah, good question. Okay, I think that's a fair question. Again, I'll go back to every case, and prosecutors in our office, we look at it on a case-by-case basis. And, you know, being a nonviolent offender, that's or low level, I think, as you said, that's only a part of it. I mean, again, gang, if an individual is part of a gang, if there is a violent background, if this is not their first time being caught up in the criminal justice system, there are a number of factors that go in. And so what we're careful to do is not just say a one-size-fits-all, just because we can charge. And at one point, you know, there was, you know, policy to say seek the most aggressive, the longest sentence, mandatory, including mandatory minimums as possible. Again, I want to be clear. I don't want to be unclear that we will remain vigilant. We're going to be aggressive, but at the same time, we're going to try to remain smart and take a holistic approach on a case-by-case basis, as opposed to kind of a wholesale approach of just because we can and have, you know, the facts to support charging in a certain way, that we will look literally at every case. And even after, you know, certain things may or may not change after a case has been indicted or complaint filed, that's again on a case-by-case basis look at it. And I know many of you all have come in and said that, hey, look at my guy, he's a little different, or this person, and here's some facts. And again, I'm willing to listen. Prosecutors, we're willing to listen. But again, as I stated earlier, I don't want this to, and this has been a debate going around, and not a serious conversation even at the U.S. Attorney's Office, U.S. Attorney's Conference last month in Washington, of just, I would say, mixed signals. People really want to understand, and frontline prosecutors really want to understand what does smart on crime mean. And what I got from the Attorney General is that the judgment, he's trusting the frontline prosecutors, so there's no mandate to say you cannot charge or you can't, but literally every case should be looked at upon its own merits, and that's where we start.
So one of the objectives you mentioned when you were speaking was sentencing reform, and I'm curious if you're aware, is the Department of Justice considering joining organizations like the Sentencing Commission in advocating further reducing the disparity between crack and powder cocaine sentences, or reducing some rather than just not charging the mandatory minimum offenses, trying to eliminate a lot of those mandatory minimums?
I do know that there has been an effort by the Department of Justice, being led by Attorney General Holder, from the Fair Sentencing Act to the disparity that you mentioned, crack and powder cocaine, to do just that. I mean, that has been, this Attorney General has been very active and proactive in that regard. So, yes, to answer your question, yes. Chief? Oh, I'm sorry, there's a question first in the back. To answer your question, no. And I'm not sure that we can. If I understand your question correctly, is when individuals from the U.S. Attorney's Office and from the State DA's office, Amy Wyrick's office, there's the PSN, the Project Safe Neighborhood Unit, when we're sitting down and looking, and I'll tell, you know, I say all the time that for prosecutions on the federal side, I'm looking for the worst of the worst to take federally, and oftentimes there's a state offer that's made, and individuals, again, that are just didn't get the memo, and again, wreaking havoc in our community. But to have a defense attorney sitting down at the table pre-indictment, I'm not even sure how that would, I'm not sure how that would work. So maybe I'm missing the question, but I don't think that would, I'm just not sure that would work, having anyone outside of the prosecutor sitting at the table.
All right. One more question for Mr. Stanton, and we'll call off the dogs.
Sure, you can ask. On what?
Like requests for diversion.
Sure. I mean, there is a process. I will always tell the frontline prosecutors, and let me say this, ultimately it's my decision, but I give a lot of deference to the frontline prosecutors who've been with the case from its infancy stages through investigation, through charging. You know, we have a pros memo that goes up in every U.S. Attorney's office, so there's a lot that goes into it. And so, you know, one question we have to ask is, you know, are we indicting cases that never should have been indicted if we're suggesting diversion? Now, obviously, things change, circumstances change, and are made known in a subsequent manner. But yes, I would still recommend, and that is the protocol, is to go with the frontline prosecutor up through the criminal chief and to myself. I think there was one other hand.
Last one.
One of the consequences of some of the statistics that you recited, the disproportionate numbers of black men and other members of communities of color that have been locked up in poor communities, is that a lot of those communities have formed adversarial relationships with law enforcement. What kinds of things is your office doing as a part of your safe neighborhoods, doing smaller crime prevention schools, and other communities form positive relationships with law enforcement, like mentoring programs that are happening, so that the only time that folks in those communities see law enforcement isn't when somebody's being locked up?
Yeah, excellent question. Part of that coordinator position that I mentioned, David Biggers, AUSA Biggers, was him. That's a part of, we have an outreach, and I'm proud of the outreach efforts that we have. There's not a week that goes by that I'm not in front of a school talking to students. I guess this week yesterday I was at the University of Memphis. I'll be at Stacks Academy next week. But we also, not only that, but personally I've been out to the federal prisons. We have something called Ceasefire, where we're talking to individuals before they're paroled, making sure they understand that once you're released, if you are caught with a gun or ammunition, you have to be discharged, and you all know the statutes, that the felon in possession, what you're looking at. And so trying to be proactive, not only as young as the grade school level and up to the college level, but even doing something, and it's interesting, when we go out to the federal prisons, how many individuals will show up and say, hey, wait a minute, the U.S. Attorney and his staff want to meet with us. There's got to be something to it, and oftentimes they know many of the AUSAs by name, because I guess they prosecuted the case, and they're waving as we're walking on campus through the cafeteria or whatever, and making comments. But it's something that, again, and it's a testament to all of us working on the same page with this reentry court. Obviously, Judge Breen and Doris and Alice Cunley in probation and Carolyn Moore in pretrial, that we're all swinging for the same thing, and that is hopefully that those that get caught in the system, well, first, prevention, making sure individuals do not get caught in the system. And I can relate to a number of the young men and women in the schools, because I'm a product of the school system, from public school, from preschool to law school. I was educated right here, so a lot of times that resonates. I grew up in South Memphis and Whitehaven. But also for those that have gotten caught up in the system that really deserve and want that second chance, we're going to do all that we can to swing to make sure, if you're serious about not coming back, working together to do that. Now, if you're not serious, obviously, we'll use every bit of our weight and influence with the Department of Justice to ensure justice is done.
All right. Thank you.
Thank you.
Attorney.